The main section involved in this case is section 170 CRPC, which deals with the cases to be sent to magistrate when evidence is sufficient. So, reciting that section, if upon investigation under this chapter, it appears to the officer in charge of police station that there is sufficient evidence or reasonable grounds, then such officer shall forward the accused under the custody to a magistrate empowered to take cognizance of the offence upon a police report and to try the accused or commit him for trial. Or if the offence is bailable and the accused is able to give security, then the investigating officer shall take the security from him for his appearance before such magistrate on a day fixed and for his attendance from day to day before such magistrate until otherwise the magistrate directs. So in this case, the respondent contended that the trial court has taken a view that unless the accused is taken into custody, the charge sheet will not be taken on record. So in this case, the Supreme Court has referred the decisions of certain high courts. In High Court, in its own motion versus CBI, the Delhi High Court dealt with similar scenario. The Delhi High Court observed that the word custody envisaged in section 170 doesn't contemplate either police or judicial custody. It merely connotes the presentation of the accused before the court at the time of filing of charge sheet, and after that, the role of the court starts. So, for reaching such a conclusion, in that case, the court elucidated the legislative intention of section 170. The court observed that the power to release the accused on bail is conferred upon the investigating officer under this section. If the offense is bailable and the accused is able to give security for his appearance before the magistrate, even after finding that there is sufficient evidence to put the accused on trial. Actually, power alla confer ചെയ്തേക്കുന്നത്. Actually, the word used is shall. So, it is obligatory for the investigating officer to release the accused on bail if the offense is bailable and the accused is able to give sufficient security for his appearance. ഈ പി ഡി എഫിലും പവർ എന്നാണ് കൊടുത്തേക്കുന്നത്. അപ്പം മേ ബി ഐ തിങ്ക് ഇറ്റ് ഈസ് ഒബ്ലിഗേറ്ററി for the investigating officer to do so.
Okay.
If the intention of the legislature was such that the accused has to be kept in police custody during the filing of charge sheet, the said obligation wouldn't have been conferred to the investigating officer. And it also observed that if the investigating officer is satisfied that the accused wouldn't disobey summons or abscond, as he has been cooperating with the investigation and investigation can be completed without arresting him, the investigating officer doesn't have an obligation to uh, take him into custody. So therefore, even if the offenses are non-bailable and cognizable, the police or the investigating officer is not duty bound to arrest the accused and take him into custody if it is not essential for the investigation. Even in section 41, it is provided that the police officer may, without an order of the magistrate or without warrant, the word used is may. So it is left to the discretion of the investigating officer. So the Delhi High Court observed that the arrest shouldn't be opted in ordinary course. The arrest shall be resorted to only in case of absolute necessity and for completing the investigation, like for a recovery of any kind of incriminating articles like weapons or tools associated with that offense, or to elicit any kind of information regarding the accomplice or circumstantial evidences. Also, arrest can be made if the investigating officer thinks that the presence of accused will be difficult to procure because of the uh, uh, depth of the offense. So, and there is possibility of fleeing or absconding from the justice. And also, the Supreme Court referred the decision of Gujarat High Court in Deen Dayal Kishan Chand and others versus State of Gujarat. It was observed by the High Court that the refusal to accept the charge sheet either by magistrate or by the court staff on the ground that accused is not produced is not supported by any provisions of law. Therefore, at any time when the charge sheet is produced, the court has to accept it, and the magistrate or the staff is free to make any endorsement on the charge sheet pertaining to any omissions or any defects in the requirement of charge sheet, but it has to be accepted by the court. So it is obligatory on part of the magistrate to accept the charge sheet whenever produced, and also keep in mind the bar under section 468, which bars the taking of cognizance after a lapse of a certain time period. Therefore, the Supreme Court in this case held that there is no need to arrest each and every accused at the time of filing a charge sheet. Also, the court mentioned the constitutional importance of personal liberty, which cannot be taken lightly and can be curtailed only when a custodial investigation become absolutely necessary. Another important point mentioned by the apex court is that merely because an arrest can be made because it is lawful doesn't mandate the arrest must be made. So a distinction must be made between the existence of power to arrest and justification for exercise of it. Accordingly, adopting the ratiocinations of the High Court, the impugned order was set aside and the appeal was allowed.
Siddharth versus State of UP is a case which comes as a vertex of a triangle, which has two other cases with the two other sides. One is Siddharth versus State of UP. The second case is Amanpreet Singh versus CBI. And the third one is the most infamous case, that is Satyendra Kumar case. So all the three cases deal with the same issue here. But they culminated in Satyendra Kumar case, which was adjudicated by the Supreme Court in October 7, 2021, which gave guidelines as to giving pre-arrest bail before charging of before submission of charge sheet, etc. So in the present case, that is Siddharth versus State of UP, as already exemplified by almost all the respected members here, it was issue of whether he has to be arrested on the production of a charge sheet before a magistrate, as the magistrate was not accepting the charge sheet without his arrest because of the Section 170 CRPC, which mandates the accused to be brought in front of the magistrate concerned to effect arrest or for the accepting of charge sheet. And the appellant in this case is a supplier of stone, and he was booked with seven other people, with 83 other private persons, and with for an FIR which was registered 7 years ago. Almost all the other persons were given pre-arrest, anticipatory bail, uh, on the filing of a police report, and he, in this case, was given an arrest memo, even though he cooperated with the investigation. So trial court was not accepting the charge sheet without his arrest, and the Supreme Court was given afresh because Supreme Court was considering this issue afresh in the present case. This case, Siddharth versus State of UP, was cited in another case, which is Amanpreet Singh versus CBI, which was adjudicated in September 2nd of 2021, and consequently, the same issue was dealt with regard to various other type of issues. For example, in the case of heinous crimes, what is the approach of the court? In case of economic offenses, what has to be the approach of the court? Or in other special acts like Prevention of Money Laundering Act or such type of special legislations, what is the call which the court has to take? All these cases were discussed almost with concernity in Satyendra Kumar case. So now we have Satyendra Kumar case, which is the advanced version of this primitive case that we have in our hand, which is Siddharth versus State of UP. Nevertheless, Siddharth versus State of UP serves as a precedent for specific issues with regard to filing of charge sheet in this matter. Now, various citations of cases such as Delhi High Court case was cited here, which is court on its own motion versus CBI, which was very well explained by almost all members. And the main issue in this case is giving leverage to the investigating officer. If the investigating officer is not given leverage, he cannot let go the accused on station bail with or without security in cases of bailable cases. Uh, and if that was construed to be part of, taking cognizance by a magistrate, or him, the person must be taken to the in front of a magistrate, then magistrate will be only person to give bail. Investigating officer cannot give bail in the absence of, this, in the absence of, mm, uh, what do you call, um, evidences to support. In such cases, the investigating officer will not be the authorized person to give bail. It will be only the magistrate. So Delhi High Court clarified that point in the case of court on its motion versus CBI. And again, it reiterated the same issue in another case, which is court on its motion versus state, which is also a Delhi High Court case, wherein it gave a clear view that it is not essential in every case involving a cognizable and non-bailable offense that an accused be taken into custody when the charge sheet or the final report is filed. And in other case, which is Deen Dayal Kishan Chand and others versus State of Gujarat, it was given by the court that the refusal of the criminal court, either through the learned magistrate or through their office staff, to accept the charge sheet without production of the accused person is not justified by any provisions of law. That was the contention. The same was accepted by Supreme Court in this case, and mainly in my opinion, Supreme Court gave much importance to the personal liberty aspect, which is Article 21 of the accused person or the uh, person or the victim. I mean, to the appellant. Herein, uh, we have already discussed certain other cases, such as in Vikramjit Singh case. Also, the due process of law also constitutes part of Article 21, as it says. In that matter, also, even small variations or interpretations of sections of CRPC will have profound impact when it comes to the administration of justice and protection of fundamental rights, especially such as that of Article 21. So this case assumes penultimate importance in that aspect, in my view. And Joginder Kumar versus State of UP also exemplifies the same issue here. That is, a clear distinction must be made between the exercise of power to arrest and the justification for the exercise of it. Joginder Kumar case becomes connected to DK Basu case, and DK Basu case gets connected to uh, the infamous case of dealing with 498 IPC, which is uh, I'm not remembering the case name, but it was a famous case and it is used as a precedent.
Arnish Kumar.
Arnesh Kumar, yes, sir, yes, sir. Arnesh Kumar versus State of Bihar. So Arnesh Kumar versus State of Bihar gets connected to Satyendra Kumar case, and the issue is amicably resolved in Satyendra Kumar case. That is my analysis.